Good afternoon. This is Pastor Bob Uzzle from the Bethel African Methodist Episcopal Church, Corsicana, Texas. This is this is July the 2nd, 2020. June's gone. I hope everybody's having a good day. I want to talk about Gregg versus Georgia at 44. It was on July 2nd of 1976. That was 44 years ago today. It was just 2 days before the celebration of the bicentennial of the United States. Anybody who's old enough to remember, uh, even though patriotism is certainly a very good thing, many of us back in '76, before the year was over, we'd been hearing so much about the bicentennial that we got tired of it. But it was quite a phenomenal event. I was living in Teague, Texas at the time, working for the state, and I was involved in some bicentennial activities at the local park. I played my guitar and sang a couple of songs at these various events. But I remember when the Gregg decision was handed down. The other day, on June the 29th, we did a video concerning the 48th anniversary of Furman versus Georgia. Both of these cases are very important in constitutional law. Both deal with a very controversial issue, that of capital punishment. On June the 29th, 1972, the U.S. Supreme Court, by a 5-4 decision, struck down the existing death penalty laws that existed in the United States. The court did not declare capital punishment per se to be unconstitutional, but it declared that the laws as existed at that particular time were unconstitutional. The door was left open for resumption of executions if the laws could be made to conform to constitutional standards. Many thought that Furman would bring the death penalty to an end, but it didn't. Various states, including my home state of Texas, went to work and rewrote their laws to meet constitutional muster. And then on July the 2nd of 1976, Gregg versus Georgia gave the green light for resuming executions, again just 2 days before the bicentennial. There was companion cases: Prophet versus Florida, Jurek versus Texas, Woodson versus North Carolina, and Roberts versus Louisiana. They were all heard at the same time. The U.S. Supreme Court reaffirmed the acceptance of the use of the death penalty in the United States, upholding in particular the death sentence imposed on Troy Leon Gregg, referred to by a leading scholar as the July 2nd cases, and elsewhere referred to by the lead case of Gregg. The Supreme Court set forth the two main features that capital sentencing procedures must employ in order to comply with the Eighth Amendment ban on cruel and unusual punishment. And this essentially ended the de facto moratorium on the death penalty imposed by the court 4 years earlier in Furman versus Georgia. In case anybody's not familiar with the idea of a moratorium and abolition are not the same thing. Abolition is when you get rid of the death penalty completely. A moratorium is when you still have the death penalty on the books. You still have capital murder trials. People are still sentenced to death. You still operate death rows. But just while the moratorium is going on, you don't execute anybody. And this brought this to an end, and sometimes the term post-Furman is used to describe executions committed since the Furman and Gregg decisions were handed down. And the court upheld, the states of Georgia, Florida, Texas, North Carolina, and Louisiana amended their death penalty statutes. And most of them were upheld, although they did not uphold the statutes in North Carolina or Louisiana. In the July 2nd cases, the court's goal was to provide guidance to states in the wake of Furman. In Furman, only one basic idea could command a majority vote for the justices. Capital punishment, as then practiced in the U.S., was cruel and unusual punishment because there were no rational standards to determine when it was imposed and when it was not. That was a 5-4 decision in which there were the 5 justices that voted to strike down the death penalty laws only included 2 abolitionists, William Brennan and Thurgood Marshall. They believed that death penalty was cruel and unusual punishment in all cases. William O. Douglas, Byron White, and Potter Stewart accepted the legitimacy of capital punishment, but felt like the way it was being administered at the time was cruel and unusual. The 4 dissenting justices who, the 5 I mentioned, who voted to strike down the laws, had all served under Chief Justice Earl Warren, who retired in 1969. The 4 dissenting justices, Chief Justice Warren Burger, Harry Blackmun, William Rehnquist, and Lewis Powell. All of these voted to strike down not to strike down the death penalty laws. They were unconstitutional as were. All 4 men had been appointed to the court by Richard Nixon. Now, four years later, things have changed. William O. Douglas, the great libertarian, retired from the court in 1975. He was succeeded by John Paul Stevens, who started out as a moderate judge, but when he retired a few years ago, he had become one of the more liberal judges on the court. And John Paul Stevens voted with the majority. And there was actually only 2 dissents in the case, and that was William Brennan and Thurgood Marshall. And so this again gave the green light. It was a companion case that went differently, was the Adam Woodson versus North Carolina, in which the mandatory death penalty was struck down. A mandatory death penalty, if you have a crime that's committed in a certain manner, the only options the jury has is the death penalty or acquittal. That was rejected, but the laws that were passed in Georgia, Florida, and Texas were all held to be constitutional. Both Congress and 35 states had complied with the court's dictates in Furman, but either specifying factors to be weighed and procedures to be followed when imposing a death sentence, or dictating the death penalty would be mandatory for specific crimes. Furthermore, a referendum in California had challenged the California Supreme Court's earlier decision in California versus Anderson, holding the death penalty violated the California Constitution. The fact that juries remained willing to impose the death penalty also contributed to the court's conclusion that American society did not believe in 1976 that the death penalty was unconstitutional. With the focus on civil rights and human rights and other social developments during the 1960s, efforts to get rid of the death penalty increased during that time. But in the 1970s, things started going the other direction. The court found the death penalty comports with the basic concept of human dignity at the core of the Eighth Amendment. The death penalty serves two principal social purposes, they ruled: retribution and deterrence. Today, some people still believe that. More and more people are beginning to question that, however. The rationale on this day in 1976, the court was determined to simultaneously save capital punishment, at the same time impose some reasoned basis for carrying it out, to mitigate the harshness of the common law rule. When this had come down originally, way back in 1794, it was Pennsylvania that came up with the concepts of first-degree murder for a capital crime, limited to all willful, deliberate, and premeditated murders. All of the murder was second-degree murder, not a capital case. In various states went in various directions, but by 1963, all states that had the death penalty employed some form of discretionary sentencing. Some states do have first degree and second degree, sometimes called murder one and murder two. In Texas, the terms are murder and capital murder. Not every case of murder is capital murder. But the court set out two broad guidelines that legislatures must follow. The scheme must provide objective criteria to direct and limit the death sentencing discretion. Objectiveness of these criteria must in turn ensure by appellate review of all death sentences. And second, the scheme must allow the sentencer to take into account the character and record of an individual defendant. At some point, the term was used and developed a continuing threat to society. They've got to consider aggravating factors that make it worse, mitigating factors that make it not as bad. When I was taking a death penalty seminar at UTA, we had a speaker to our class who was a mitigation specialist, a social worker. And mitigation specialists generally do not testify in the cases, but what they do background research, and they try to find family, friends, former employers, etc., somebody who could say something good about the person that might demonstrate they have redeeming social value. And the term society in this context can include prison society. Would this person be liable to commit crimes against other inmates or against corrections officers? And that's part of the consideration used. The drafters of the model penal code conclude the now familiar bifurcated procedure in which the jury first considers the question of guilt without regard to punishment. And then if they're found not guilty, that's where it all ends. But then determines whether the punishment should be death or life imprisonment. And this has become a very widespread model. And a lot of different states have gone in various directions since then. Some states have no death penalty at all. Some have the death penalty on the books, but very seldom carry it out. Then there's others who use it on a regular basis. It was Justices William Brennan and Thurgood Marshall expressed a dissent in this case. The same thing they articulated in Furman, that the death penalty does not deter crime, that American society has evolved to the point that it is no longer an appropriate vehicle for expressing retribution. In every subsequent capital case that would come before the court during their tenures, they would refer to their opinions in Gregg in support of their vote against the death penalty. Their position on the issue was clear. It was crystal clear. It's unconstitutional, it's cruel and unusual punishment. The only solution is to get rid of it. Now, one of the dissenting justices in 1972 and one of the justices to write in the majority in 76 was Harry Blackmun. Throughout much of his career, he supported capital punishment. Then a few years before he retired, he changed his position. And in a decision that he wrote, he stated that he for years had tried to work within the system. He tried to make the practice constitutional, to make it fair, so that there would be equal. One person wouldn't be more likely to get the death penalty based on race or based on economics or based on the other factor. But before it was all over, Justice Blackmun threw up his hands. There's no way to make it fair. And he said, I'll never again tinker with the machinery of death. He presented the view that future generations would one day abandon the practice. Now, in 1976, John Paul Stevens had only been on the court about a year. He voted in favor of it. But in October 2010, in an interview, he said that his vote in this decision was something he regretted. He wrote that his vote was made with respect to precedent within the court that held capital punishment to be constitutional. So toward the end, he changed his mind. Utah was the first state involved in what I call the post-Furman executions. It took place on January the 17th, 1977. Gary Gilmore was put to death by firing squad. And it's very interesting that it was also in the year of 1977 that France used the guillotine twice. Shortly after this, France abolished the death penalty. And so these 1977 executions were the last that France conducted in the 20th century, perhaps for all time. The United States and Europe began moving in very different directions, with the United States making increased use of capital punishment and Europe moving away from it. Only Belarus is the only European country that still uses the death penalty, and both the European Union and the Council of Europe are totally opposed to the death penalty. Now, Gary Gilmore was a voluntary execution. He had waived appeals, tried suicide in prison, and wanted to be put to death. The first non-voluntary execution occurred in 1969 with the death of John Spinkelink in the Florida electric chair. And have been a number of other decisions. There have been some that have favored the abolitionist movement to an extent. You can't execute someone who was mentally handicapped or someone who was under 18 at the time of the crime. And in one decision, they declared that rape could not be a capital crime. If the person didn't die, there was actually two decisions about that. One involved the rape of an adult. The other, it was in 2008, in which they struck down the Louisiana law that allowed the death penalty for rape of a child. And they said someone has to die in order for this to be carried out. Although it may still theoretically be possible for someone to be executed for treason. That has not happened since the 1950s when Julius and Ethel Rosenberg went to the electric chair for selling military secrets to the Soviet Union. And so anyway, in the state of Texas, in September 1st, 2005, Texas adopted life without parole. And to be effective for crimes committed since that date. And so as a result, with juries having the option of sentencing people to life imprisonment without the possibility of parole, even in Texas, the number of new death sentences has been reduced. Texas, as I said, passed rewrote the capital punishment laws and passed them during the summer of 1973. It was on December 7th, 1982, that Charlie Brooks Jr. became the first person in history to die by lethal injection. He was from Fort Worth, and Texas pioneered this new method of execution, which since then most states have adopted. And I was allowed to make remarks at the funeral of Charlie Brooks Jr. on December 10th, 1982. But right now, this is the last day of the fast and prayer, the what's called Starving for Justice demonstration being held in Washington, D.C. Obviously, a lot of it's being done online like everything else due to the coronavirus. The coronavirus has also slowed down executions because of concern of safety in prisons when this is done. And so we'll see how that goes. But the Starving for Justice, this is the 27th year. It begins on June the 29th to mark the anniversary of Furman versus Georgia. Ends on July 2nd, which is today, to mark the anniversary of Gregg versus Georgia. It's been 48 years since Furman, 44 years since Gregg. One of the leaders of the march said he's been coming to Washington on this day for the last 27 years, and he plans to continue to do so until the death penalty is abolished. Have a good day.